with you from the courtroom. What will happen is during recesses, you just put your notepad down on your chair. Obviously, when you go back and deliberate, you'll be able to take your notepad with you to help refresh your recollection. As I said yesterday, the purpose of all this is not for other people to look at your notes or to rely on your notes, but for you to refresh your recollection in regard to what you may have seen and heard in the courtroom. When the case is completely over, the bailiff will collect your notes and give them to my judicial assistant. She will destroy them. That's one of her favorite jobs, especially compared to the other things that I give her. And no one will ever read your notes but you. If you do take notes, do not get so involved in note-taking that you become distracted from the proceedings. Your notes should be used only as aids to your memory. Whether or not you take notes, you should rely on your memory of the evidence, and you should not be unduly influenced by the notes of other jurors. Notes are not entitled to any greater weight than each juror's memory of the evidence. So if you can write your name nice and big on the first page, and then if you do want to take notes, you can start on page 2, and that way if anyone sees your notepad, they'll see your name there, and they'll know that it belongs to you and it doesn't belong to them. All right, any questions? Mr. Schaub, you may proceed with your opening statement.
You need to stop this behavior. You need to knock it off. It's not worth it. I can't help myself. It always gets me in trouble.
Objection, Your Honor, argumentative, and it's not a statement of the what he intends the proof to show. He hasn't indicated that.
Overruled.
Those are the words of the defendant on February 14th, Valentine's Day of last year, when he got into a parking lot altercation at the Circle A convenience store in Clearwater. Those are his words. 5 months later, those words rang true. Because on that day, he got into another parking lot confrontation with a young African-American female named Brittany Jacobs. And her partner, her boyfriend, the father of her 3 children, came to her aid, and he did not drive home that day, as he found himself dying on the floor of that same convenience store 5 months later in Clearwater, Florida, as his 5-year-old son looked on. Good morning. Yesterday, the day before, we had an opportunity to ask you all a lot of questions. Well, today there should be 2 questions you have of Mr. Rosenwasser and myself. What are you going to prove to us, and how are you going to prove it? What we're going to prove to you during the course of this trial is that the defendant in this case is guilty of the crime of manslaughter. Now, we've watched a lot of TV, we talked about that. We've heard about, premeditated murder. No, he's not charged with first-degree murder. We've heard about ill will, hate, spite, evil intent, second-degree murder. No, he's not charged with second-degree murder. What he's charged with is manslaughter. He took the life of another human being unlawfully, without any legal justification. And that's what we're going to prove to you during the course of this trial. Now, how are we going to prove it? 2 ways. By evidence, things that you're going to be able to see. You're going to see the video of that incident from start to finish. Things that you're going to be able to hear. You're going to hear the defendant's statements. Things that you're going to be able to take back with you to that jury room when you deliberate. Feel and touch the gun, his holster that he was wearing that day. All those type of things. And we're going to do it by way of testimony. Ladies and gentlemen, witnesses are going to come into this courtroom. They're going to sit right here and they're going to take an oath. Now, our goal in this trial, believe it or not, our goal in this trial is twofold. One, to ensure that Mr. Drejka receives a fair trial. He is presumed innocent by each and every one of you. But at the close of this trial, we're going to ask that you take that presumption away. But he, like anyone that walks into a courtroom in our country, wants a fair trial. And we're going to ensure that. The second thing we want to make sure by way of the testimony, by way of the evidence, is that you have an opportunity to almost be there, to see exactly what happened, so you can make the decision in this case. You are the judges of the facts of the evidence in this case. The close of this trial, the judge is going to give you the law, and you to apply that law to that evidence. And we're confident you'll do that. And what you're going to learn by the way of the witness testimony. And first you got to start, let's go chronologically. You got to start on that Valentine's Day. A young African-American male was working, Rick Kelly. He was working for a septic tank company. That septic tank company's offices were right around the corner from this convenience store. The convenience store was on the corner of Sunset Boulevard and Douglas Avenue in Clearwater. That business was right around the corner. Rick Kelly's going to testify to you. He's going to tell you since he was a little boy he went to that convenience store. He'd always go into that convenience store. He had such a relationship with the owner of that convenience store, he could pick up items and pay at the end of the week. Pick up items, say, Ali, I've got such and such. And at the end of the week, he'd pay for the items. So on this particular day, Mr. Kelly was at work. He's been working at the septic tank company for some time. He was finishing up for the day. It was a hot day, and he was going to run into the convenience store and grab himself a soda to drink. And that's what he did. Matter of fact, he left his tanker truck running. And this is a big, big tanker truck. He left the tanker truck running. And in the front seat of that tanker truck, he had money. Because what he would do is go to the accounts and empty out septic tanks or fix septic tanks and do that type of thing. And then people would pay him by cash or by check. And he would keep all that money in the front seat of his compartment there in that truck. He left the truck running because he was going to just run in and run out. And matter of fact, he ran in, picked up a soda, said, Ali, I got a soda. Didn't even go to the register with him. And then when he went outside, he saw a man, the defendant. He saw this man right here. And he saw the defendant walking around his truck, peeking in the windows, taking out his phone and taking pictures of his truck. And he's like, whoa, what are you doing around my truck? Remember, he has money in that truck. He has checks in that truck. That truck was running. What are you doing around my truck? Get away from my truck, sir. Are you handicapped? No? Are you? That doesn't matter. Well, are you with somebody that's handicapped? That doesn't matter. What are you doing parking here? And then a confrontation started. An argument started. It got heated. Curse words were used. It got heated. It got loud. At one point in time, Mr. Drejka went over to his truck, went into the truck and came back out. It got so loud that the store owner, Mr. Ali Salas, he's the owner-operator of that convenience store. He works 7 days a week. Every day he works. Morning shifts. And he heard the argument because it was so loud. And he went outside and he tried to calm down the situation. And Ricky, who he knows, said, all right, I'm leaving. Ricky said, I'm leaving. But before Ricky left, the defendant made a threat to Ricky Kelly. He said, I could shoot you. I could blow your head off. Ricky was a little upset. Ricky thought he might have to get physical, but he didn't. He got into his car. I'm sorry. Into his
John, let's
truck.
object if we could approach.
Okay. Mr. Shaw, you may proceed.
So he threatened him with a gun. Now, Mr. Kelly's going to tell you he never saw one. He never saw a gun whatsoever. But Mr. Kelly had one more thing to do for work, so he got into his truck and he left the location. And he was going to go empty out the septic tank over in Dunedin at a facility there. So he had one more thing to do. On that drive, he had a phone call from the owner of his business. The owner of his business is John Tyler, and he's going to testify to you. Mr. Tyler's going to tell you he received a voice message on his phone from the defendant. The defendant was upset about his employee, Rick Kelly. Mr. Tyler was going to call him back, but he wanted to find out what it was all about. He called Mr. Kelly, he found out what it was all about, and then you're going to hear about the phone call that he had with the defendant. Listen carefully to Mr. Tyler. Because Mr. Tyler called him, he said he was, Drejka, the defendant, said he was angry and he was upset about the parking that his employee did. Mr. Tyler asked him, are you handicapped? I'm sorry. He said, no. Well, were you with somebody that was handicapped? No. All right, well, I apologize. It got heated to a point where he said he's lucky I wasn't carrying because I could have shot him. He said that to Mr. Tyler. Mr. Tyler, a carrying concealed weapon permit holder, said this conversation's not going anywhere. You mean you can shoot someone over a parking spot? And he terminated the phone call. But before he did, he said, go ahead, you can call the police. I'll talk to them if I need to. Remember I said that that argument got loud. Mr. Salas, the owner, heard that argument. And he went outside and he checked it out, calmed it down, had Ricky drive off. Then he had a conversation with the defendant. And this is important because his conversation as that owner of that business, he said, you need to knock it off. You need to stop this behavior. It's not worth it. Mr. Drejka acknowledged that he knows it's wrong, but he can't help himself. It always gets him in trouble. Now, we need to go forward. Oh, let me talk about another witness you're going to hear from Nelson DeLeon, detective, the Pinellas County Sheriff's Office. And he's going to tell you how he came about finding out about this incident. And listen carefully to when he tells you. Because when Ricky, on that day of the incident, now we're going to go forward, all right? We're going to go forward to July 19th of last year. 5 months later, on July 19th, Marquise McLaughlin was killed at that convenience store. Ricky was working AAA Septic. He walked by, he noticed a vehicle in that parking lot, a silver SUV. He remembered that silver SUV because that silver SUV had been the car driven by the defendant in the altercation in February. He went and told his boss. He did not want to get involved. His boss kind of guilted him to get involved. Said, you got to tell them what you know about that car and the operator of that car. So he walked over to the scene. Law enforcement was there, tape was up, Detective DeLeon was there. And he walked up to Detective DeLeon and said, is this car involved in anything? He didn't know what had taken place. He didn't know if a shooting had occurred. He didn't know if what had occurred. He didn't know who was the victim. He didn't know if the victim was a female, if the victim was a male, if the victim was white, Asian, African American, or what. He had no idea. Detective DeLeon said, well, I don't know. All the cars are important. Why? What do you know about the car? He told him the story of what had happened a couple months earlier at that same convenience store. And you're going to hear about that. He had no agenda. He told him what happened on that day, on July 19th. Now, let's talk about July 19th. July 19th was a typical day for Marquise McLaughlin. 28 years old, father of 3. Had a baby on its way. Marquise lives with Brittany Jacobs. That's his partner. They've been together for 10 years. They were high school sweethearts. They went to Dunedin High. She was 3 years
Your Honor, I
younger.
object if we could approach.
Okay.
Who's 5 years old. Marquise worked during the night at the 7-Eleven located on Drew Street in Clearwater. He worked during the day, watched the kids, they lived together. Brittany Jacobs would work during the day while he watched the kids. Brittany worked at East Bay Rehab Center, caring for the elderly, people with dementia.
Your Honor, again, relevance.
All right, overruled.
That's what she does. That was her job. She was a certified nursing assistant working at East Bay Rehab Center. That's where she was that day. She worked from 7 to 3. She got off work at 3 o'clock. Marquise picks her up, just like he always does. He had the 3 kids in the car. He picks her up, she decides to drive, she drives, and stops at the Circle A convenience store. Now you're going to hear her family grew up around the Circle K. Marquise's family lived around the Circle K. They've been to the Circle A convenience store. Brittany pulls up. She parks in a handicapped parking spot. We're not going to say that's right. It's not. But she parks in a handicapped parking spot. Marquise has his two kids in the car, and he's going to run in to grab some sodas and some candy or food for the kids, and some snacks. And you're going to see the car pull up, park into that spot, and you're going to see Marquise get out of that car with Marquise Jr., the 5-year-old, and he walks with that child inside the store. And you're going to see him inside the store. And you're going to see him walk inside the store and even go to the cash register. But while he's doing that, there's something going on out in that parking lot. And it's the defendant. And he confronts Brittany Jacobs. And he starts in about her parking in a handicapped spot. But watch, because you're going to be able to see this. Watch what he does when he goes into that, when he approaches that car. He parks his car, he gets out, he walks around that car, peeking in the windows of her car, walks to the back of the car, the front of her car, looking in the windows. She's concerned. She's by herself. She has 2 young babies in the car. And here's some crazy guy walking around the car.
Objection, Your Honor.
All right, overruled.
Here's some guy walking around her car that she has never met before. And he starts in out. And this is ironic. Look at this video. Look where he's parked. He's not parked legally. He's parked not even in a spot. He pulls up in a non-parking spot to complain about her parking. Look at that. Look at that video. He's not parked legally. He complains about her parking. Are you handicapped? What's it to you? Are you, in and in? Arguing, cursing, the whole 9 yards goes on. Meanwhile, you're going to see on that video, you're going to see people walking into that store. People coming in. Now remember, it's broad daylight, in the middle of the day. And people are walking in and out of that convenience store. Look at the people that walk in and out of that convenience store. Watch them very carefully. Look at them. You're going to see them. They all look in that direction. They all look over at that confrontation because it's loud, because he's arguing with this young female. It gets their attention. Matter of fact, Mr. Robert Castelli, a witness in this case, pulled in. And you're going to hear it caught his attention, and he's going to tell you he was concerned. He thought about going over and interjecting himself, but he didn't. Instead, he listened for a while, and then you're going to hear he went to the front door, and he told the store owner in there, and you're going to see this on video. Marquise is right there with Marquise Jr. at that store, getting ready to buy his stuff. Mr. Castelli comes to the door, and Mr. Castelli says, there's a problem out here in the parking lot. There's a problem out here. I think you better do something. Marquise heard that. You're going to see him put down the items, leave Marquise Jr. inside the store, walk out, and you're going to see him walk out and walk up to where Mr. Drejka was. This is the view that Mr. McLaughlin had. And you're going to see it on videotape. These are still photos of that. When he walks out of that store. 1 foot away from her window, from the mother of his children's window, from the 2 babies in that car, he was right there, finger pointing, wagging his finger at her. He heard there was a problem out there. You bet he went out to defend his family. And when he got out there, he pushed him away from that car and pushed him down. And did he push him hard? Yes. Pushed him down away from his family. He heard there was a problem out there. He saw there was a problem out there. And he pushed that person away from his family. And that's when the problem happened. Because after he did that, Mr. Drejka pulled out his gun. He was carrying a gun on a holster. He pulled out his gun. He was on the ground. He pointed that gun directly at Mr. McLaughlin. And watch carefully. We're going to show you a slow motion video, a portion of that. When he waves Mr. McLaughlin over, Mr. McLaughlin backs up. Mr. McLaughlin backs up as far as he can go, all the way to the car. He can't go back any further, and watch that video. He starts to turn away from the confrontation. And he's shot at that time. Matter of fact, the video speaks better than I can. Backs up, turns, shot. After he's shot, he heads back into the store and falls on the ground and dies in that store. You're going to see that videotape numerous times during the course of this trial. You're going to see still shots taken from that videotape. After this occurred, the defendant was interviewed. The defendant was talked to by law enforcement. Listen real carefully to that interview. It's about an hour long. Listen real carefully to that interview. The defendant uses these military law enforcement terms. He's not military, he's not law enforcement. He's 47 years old, and he's been retired for many, many years. Says he came into some money from his mother dying. And he was retired, I think, in 2006 or something, 2003. He talks about that on the video. Not in law enforcement, not in the military. Listen to what he says. He starts talking about a thing called the 21-foot rule. Actually, I think today it may be a 25-foot rule. But what that rule is, Scott, take it off. What that rule is, ladies and gentlemen, is plain and simple. If a law enforcement officer is 21 foot away from a suspect, and that suspect has a blunt instrument, a sharp-edged instrument, a knife, a hatchet, and that officer hasn't drawn his weapon yet, by the time that officer can draw his weapon, pull it out, aim and shoot, he needs to do it. Because in 21 foot, that person can close that gap with that sharp-edged object. And why is that important? Because in this case, we have no sharp-edged object. You're going to hear that Mr. McLaughlin was unarmed. No knife, no gun, no weapon of any kind on his person. He was unarmed. The 21-foot rule does not apply to an unarmed man. And you're going to hear that during the course of this trial by way of expert testimony. And I'll talk about that in a moment. He also uses a term called force multiplier, as though that justified the situation. Force multiplier can mean numerous things. One of the things, I think, it's kind of a military term perhaps, where If they have an army of 100, you better have an army of 200. If somebody has one tank, you better have two. If somebody has a knife, you better have a gun. If somebody has a gun, you better have two guns. That type of scenario. In this case, Mr. McLaughlin had no weapon. The 21-foot rule didn't apply also because that situation, the gun was already out. In the situation you saw, and watch his hand, watch it move. In the situation you saw, that controlled the situation. Ended. It's over. No, he took the life. Watch carefully him backing up. Watch carefully him turning to the side. You know, you're going to hear testimony from the medical examiner, Dr. Noel Palmer. And we're going to show you photos, specifically the entry wound and the exit wound. And he's hit on the side. Right here on the side. And the exit wound, the slug didn't actually come all the way out, but came right to the surface and caused a bruise indentation. So you can see the exit wound. The exit wound was up on the side. He was turning. He wasn't shot head on. That interview we want you to listen to. Listen real carefully. He talks about the 21-foot rule. He talks about force multiplier. He indicates Mr. McLaughlin never said one word. Never said one word. He indicates Brittany Jacobs during the argument said something about, "You want me to get my man." And I think she acknowledges that. So she said that. "You want me to get my man." But he says not one word. Mr. McLaughlin never said anything. They had no words exchanged. Mr. Drejka never said anything like stop. Never said anything. Listen carefully to that interview. He indicates that he didn't even see Mr. McLaughlin's hands. He never saw his hands. He shot this man, you're going to learn, without having even observed his hands. He never saw his face. He shot this man without even looking at his face. All he saw was his feet. All he saw was his legs. He knew he was an African American based upon the man wearing shorts and based upon the lower body. Listen carefully, because what he says is the defendant was running after he shoved me, and I pulled my gun out and I pointed it at him. He was running towards me. The detective says, "Well, what if I tell you I watched the video and I didn't see that? I saw him backing up." And his response is, "Well, I say it's wrong. The video is wrong. No doubt about it. He was running after me. I saw him twitch." Watch that video. In that interview, he was asked, "Aren't you concerned about going up to people, confronting people? You don't know them. Don't you think that type of a confrontation might scare somebody? You don't know what, you don't know what that other person, who that other person is, what might happen." You know what he says? He says, "I'm not concerned. I'm not concerned. Because I'm always carrying it." I said, "You're always carrying it. Since I was 20, 21, I'm always carrying it." Listen to that. They asked him in that interview, wouldn't the thing to do call the police? I mean, somebody parks in a handicapped spot. He says, "That's my pet peeve. That's my pet peeve." Yeah, that's fine. I understand that. That's my pet peeve. And he's asked, "Well, don't you think it would be smart to maybe call law enforcement?" "Well, by the time you get there, I mean, they're going to be gone." "All right. That's kind of what we want. Then leave the spot." No, he wants to confront that person. Listen carefully to his statements. So we're going to play that for you. It's about an hour long. And then the detectives even have him demonstrate, when he was on the ground, how far Mr. McLaughlin was from him when he shot. Watch it. Look at it. He goes, oh, back up, back up. The detective backs up. Further? Yeah, further. The detective hits the wall. He says, I can't go back any further. Well, we're going to show you exactly the size of that room. It was 9 by 11. It was a 9 by 11 room. We measured it. And you're going to see that that was a 9 by 11 room, and he backed that detective up all the way to the wall. And that's when he said, he then started running towards me. We're going to play that for you. We want you to listen to that. We want you to listen to everything. We're going to show you photographs. Photographs of the defendant's body. Without his shirt, his legs, his arms, his hands, everything. He had one injury, and that was a burn from the asphalt when he was knocked down on his shoulder. No injuries, no marks, back of the head, front, every possible position. And you're going to see the one injury there on his shoulder area. You'll see those photographs. Now, I told you you're going to hear the testimony from the medical examiner. He's going to talk about and show you and demonstrate with charts and all that the entrance wound and the exit wound and where it exactly was on the body. The cause of death was one shot by gunshot. The manner was homicide. And you're going to see that and hear from Dr. Noel Palmer. Now, a toxicology report was done, always done on autopsies. There was a drug in Marquise's system. It was MDMA, ecstasy. We've got an expert from the University of Florida, head of the toxicology department at the University of Florida, Dr. Bruce Goldberger, who's going to come in and testify about MDMA, what it is, what ecstasy is, what are the effects, and what you're going to learn that it is not a factor in this case. That's what the evidence is going to show. It's not a factor based on the amount in his system and the type of drug that ecstasy is. Dr. Goldberger is going to tell you it's called the love drug. Kind of makes you sensual. It doesn't lead to aggressive behavior. But, all right, you don't need to take Dr. Goldberger's word for that. Watch the video. Watch the video. Marquise walks out calmly, doesn't run, walks out, sees that, pushes him down, sees the gun, recognizes the gun, backs up. You're going to hear from Dr. Bruce Goldberger. You're also going to hear from Roy Bedard. Roy Bedard is, I think it's fair to say, a world-renowned expert in the area of use of force. He consults on television shows, police shows. He wrote the book that Florida Department of Law Enforcement created on use of force. He's from Tallahassee. I think he's got his doctorate today. He's had his issues. But he's going to talk to you about the use of force and what that means. He's also going to talk to you about the 21-foot rule and how it just doesn't apply in this case. He's going to mention to you about force multiplication, force multiplier, excuse me, whereas some people call it a force continuum. He's going to tell you about that and how it really doesn't apply in this case. So you're going to hear from Roy Bedard. He's coming in from Tallahassee. We're going to present his testimony to you. He's a use of force expert. Listen carefully to his testimony. At the close of this trial, and you don't get me wrong, a couple things. That incident that occurred on February 14th, that's no reason why you convict the defendant. That just goes to show intent. That just goes to show his opportunity. What we're on trial for today is what he did to Marquise McLaughlin. What he did that was improper. The taking of a human being's life without any legal justification. That's why we're in this courtroom. That's what this is all about. And he is presumed innocent. And you all need to honor that. He's presumed innocent, and that's the way our system works. He's presumed innocent until the time you hear the law, and you hear the evidence, and you see the evidence. And at that time, you go back into that jury room and you begin to deliberate. And it's at that time you can take the presumption of innocence. And we want you all to take your time and look at the evidence and weigh that evidence and listen to the law that Judge Pallone gives you. And then return to this courtroom with a verdict that speaks the truth, a verdict that says, we, the members of the jury, each and every one of us, finds the defendant guilty of the crime of manslaughter. So say we all, each and every one of us. Thank you.
Thank you, Mr. Schaub.